Good morning, or excuse me, good afternoon. My name is Dean Mel. I am the chair of the National Bar Association Alternative Dispute Resolution Section, and I am a labor and employment arbitrator and mediator based in Morristown, New Jersey. I'm going to turn this over to Rebecca Ratliff, who is an international mediator, second vice chair of the NBA ADR section, and a panelist on jams. Rebecca?
Thank you, Dean, for that introduction. I am going to have Joanne St. Louis give the housekeeping rules so everybody knows what's going to happen today. And then we will go ahead and introduce the remainder of the panelists. Joanne?
Thank you so much. My name is Joanne St. Louis. I'm the Director of Diversity Outreach at JAMS. Just before we get started, I just want to let everyone know that we will be having polling questions that will appear on your question throughout the webinar. Please make sure you answer the questions that will, be able to provide you with CLE credit. If you have any questions afterwards, please make sure you reach out to myself or to Kyle just to make sure if you missed any of those polling questions. Additionally, if you have questions that you would like to provide to the panelists throughout the program, please use the Q&A feature that you can ask your questions. You don't need to wait till the end of the program, but we'll be taking a look at them throughout the program. Thank you so much, Rebecca. Turn it right back over to you.
Right, thank you, Joanne. And now you get to meet the rest of our panelists. I would like to first introduce Judge Rhonda Trapp.
Good morning, and I'm delighted to be here. I am a retired San Diego Superior Court judge, and after serving 18 years on the bench, I am now with JAMS as a mediator, arbitrator, and neutral of all sorts. Thank you.
Thank you, Judge Trapp. Damali Peterman, introduce yourself. Welcome.
Thank you. Good afternoon. My name is Damali Peterman. It's a pleasure to be here today. I kind of have two hats that I wear. The first hat is being a mediator and arbitrator alongside Judge Trapp and Rebecca and Cyrus, who's our fellow at JAMS. And I'm also the CEO and founder of Breakthrough ADR, and I'm based in New York.
Great. Thank you, Damali. Welcome. Cyrus?
Thank you. I'm Cyrus Duggar, the principal of the Duggar Law Firm, PLLC. I am a litigator and advocate for employees in employment discrimination, wage and hour matters, and also have started a alternative dispute resolution mediation practice. And I am a JAMS Diversity Fellow with JAMS.
Thank you. Welcome, Cyrus. Tamika Hardy.
Hi, good afternoon, everyone. My name is Tamika Hardy. I am a partner at Rivkin Radler in the Labor and Employment Practice Group in Uniondale, New York. I am also an enthusiastic member of the NBA, and I'm a member and secretary of the Labor and Employment section. I have to give shout out to the Women Lawyers Division. I'm also past president of the Amistad Long Island Black Bar Association in Long Island, the most immediate past president. And I am currently serving on the Board of Governors as an affiliate representative. Thank you.
Awesome. Welcome to our panelists. We're going to jump right into the discussion because we have a lot to talk about, and it's going to be a very informative session. So I'm excited. Tamika, we talked about this and you had some really great insights during our prep. How has COVID changed litigation, and how has COVID impacted your employment practice?
So first, I'm going to talk about how it impacted our employment practice. During COVID, the entire pandemic, it didn't slow down for employment lawyers, I think, at all. Every day the law was changing, and we had to go back to our clients. By the way, I didn't say this, I represent management. And every day we were getting questions about, can my employees work remotely? What type of policies do I need to have in place if they work remotely? Can I make my employees get vaccinated? Again, what kind of policy do I need to have if I'm going to make them get vaccinated? What do I need to do if I need to do a reduction in force? How am I handling that? Because my business is slowed down during COVID. what's happening to my litigation now that the courts are closed? So we, as an employment attorney, we saw our practices just ramp up exponentially. Now, in terms of our litigation, I think that it changed the nature of the way we conduct litigation. Even if you were, I hate to say it, but a dinosaur, as a litigator, as an employer, you were thrusted into the 21st century. So you had to figure out a way how to get your employees to work, not necessarily being in the office, and also how to get them to be productive, how to manage, measure their productivity and things like that. So I think that we just, there was an explosion of technology and employment related technology, litigation related technology. So nowadays, we're doing almost everything that we did except trial virtually. And I think in some instances, they're trying virtual trials, not really, in my opinion, working out as well. But certainly in terms of court conferences, mediations, arbitrations, we're doing all of that stuff virtually. And according to various court statistics, it's not really affecting the percentage of cases that are successfully being mediated. So I think we just handling things in a different way now. I don't think we're ever going to go back to just in-person arbitrations, mediations, conferences, depositions, things of that nature.
Yes, I think that's the general consensus. And we know that the statistics are showing that virtual mediation is just as effective as in person. And so it's here to stay is pretty much the prediction. So Judge Trapp and Dean, I'm going to have you talk a little bit about the benefits of conducting virtual mediations on employment matters.
Thank you. But I first, I'm sorry, Dean. I first have to say Ms. Hardy inspired me. I'm also an enthusiastic member of the National Bar Association. I've not missed an annual meeting, with the exception of the virtual one that we all missed, since 1989. And I'm a past chair of the Judicial Council Division. So with that being said, the virtual mediation in an employment context, as Ms. Hardy said, has gone well. We're settling just as many cases as we did pre-COVID. There are, something that was born out of necessity of the pandemic has now turned into a convenience and a cost-saving measure. Nobody has to travel, and especially those witnesses that don't do so well in person. Virtual is perfect for them. It's also good for the mediator in that, we've got these little boxes to deal with now. We can be up close and personal as much as you can virtually with everybody and make those connections. So I think in balance, it's worked out well. I believe that it's here to stay. Even when most of us are back into our offices, I do think that most clients will opt at least not to have their experts fly in for a mediation. They'll just Zoom in. Dean?
Dean?
And not wishing to be outdone, I will mention that I am the immediate past chair, president of the Garden State Bar, which is the National Bar affiliate for the state of New Jersey, which is the chapter of the year. I just mentioned it. I'm also a long-term member of the NBA Labor and Employment section and have been on the board, have been an officer, and I just appreciate everything that Tamika and Kevin Reese are doing with that section. What I found, first of all, when COVID hit, I'm a traditional labor lawyer and an employment lawyer. Most employment lawyers will say L&E, but they don't do traditional. I started with the National Labor Relations Board before I did big law and then corporate. And what I found was that my arbitrations just went away immediately. in March of 2020. I then was fortunate through the FMCS and the National Academy of Arbitrators to take Zoom training. And as a matter of fact, I taught Zoom to Region 2 of the NAA, which is the New York region. What I found is that my employment mediations are higher than ever. The nature of my practice has changed from probably 2/3 arbitration and 1/3 mediation to exactly the opposite. I'm finding that now that we seem to have a lull in COVID, and I'm not saying it's done because who knows what's happening with Omicron 2.0. I'm finding the parties want to go back to the courtroom or to the hearing room for arbitrations, but Zoom mediation is here to stay. As a matter of fact, I have to drop off at 1:30 today. I apologize. I'm in the middle of an employment mediation now. So I found that the parties love Zoom mediation. It is cheaper. To Randa's point, you're not flying folks in all over. I do think that arbitration via Zoom is better than doing it in person if everybody's masked up. And as I've said to the parties, though they were unconvinced, how would you like for me to make a credibility determination? Everybody's 10 feet away and masked up, or I'm on Zoom and I'm looking at people's pores. That is not a popular view, but the mediations, and I will tell you this practice has changed. Go forward.
Yeah, so we're going to hear from Damali and Cyrus, because as a season neutral, we want to hear from her, and as a practitioner, we want to hear from Cyrus on, what best practices can you share and what best practices do you provide to your clients around virtual hearings? Damali?
Thank you, Rebecca. Something that I've found to be very useful, especially in this virtual hearing world, is to really encourage the parties to the extent possible to, prior to us having that, joint conference or that mediation, to exchange written statements, mediation statements beforehand, because, the expectation of, accomplishing everything on that call becomes a little bit more difficult if the parties don't really have a good sense of their issues, their strengths and their weaknesses. And so what I've started to do for mediations is to encourage them before a certain point, before we have our session, the joint session, to have exchange information, to tell them sort of high level what I want them to focus on as they're preparing for the session. And I give them very, clear ideas. For example, I want them to think about what their goals are, in the mediation. If they're in litigation already, what's their assessment of the other party's goals? So getting them to start thinking about what's coming up for the other side. I want them to think about what issues need to be resolved, the strengths and weaknesses of their case. I'm also asking them again to take a deeper dive into what they think the view of the cases from the opposing counsel, and also what's wrong or right about their perception. I want them to also think through the points of agreement and disagreement between the parties. So we're talking about factual, legal, and financial. I'm asking them to also think about, is further litigation or settlement the best way to accomplish their goals? And I want them to think about it for a moment, to determine before we come together in our settlement conference, whether or not they have enough information to make a meaningful settlement discussion possible. And finally, I'm asking them, so kind of putting the onus on them to think about whether there are any other creative avenues available for them to resolve their dispute. So prior to us coming together, I want them to start thinking about things that I think will really help the mediation be as fruitful as possible before we come together.
Really appreciate that. And Damali, do you do that via conversations in a pre-hearing conference and email, or
Yeah, so I send them an email, and so the email has the procedures that I just mentioned, among other things. And then I also ask for a conversation, a conference call before the hearing, before the mediation, so that we can talk about any of the things that may have come up from this sort of procedural email that I send out in advance.
I love that. I love that. And Cyrus, as a practitioner, what are some best practices that you can share that you use to prepare for virtual hearings?
So for me, virtual hearings and focusing on mediation from the practitioner perspective, for me, there's not that much I think that the practitioner is going to do differently in a mediation, or at least that I do significantly differently in a virtual mediation versus an in-person mediation. For me, the big difference maker for virtual mediations is preparing your client for that experience and figuring out how you're going to work with your client if you're not in the same room as them. So the first thing is to remind your client again and again, hey, you're on video. Don't forget you're on video. It's easy to forget. They can be talking, they can forget to mute themselves. So I take every opportunity to remind them, hey, there's someone looking into your room. Don't forget that. One important thing that I always do is I have an initial Zoom session on my own Zoom before joining the mediator Zoom, so that I can work out any technical kinks with their technology issues. I also prep them in the mediation prep on Zoom. I think it's important to see how your client is coming across on Zoom. Some people come across great on Zoom. Some people come across great on phones. We want to see the medium you're going to be actually using with your client and the mediator. Some people have some certain tics that they have on video calls that you wouldn't otherwise see. And so I make sure to prep the client in the same way that they're going to be on with the mediator, which is on Zoom or a similar platform. And also, again, the technology of that. If they can't get on a Zoom with me, I know I got a problem. I got to work through on a technological front. The other thing is that it's important to remind them that when you're on a Zoom, if you're in a mediation room with a mediator, they can't see both people's faces at the same time. So you can see more, and you're closer to people's faces and can see their reactions to things in a way you can't always do in person, because you're focusing on the person who's talking, not the person who's reacting. So I just make them aware that their reactions to things are going to be more closely scrutinized in Zoom than it might otherwise be in life or in an in-person mediation. Similarly, when I am in a virtual mediation, I sometimes look very closely. I sometimes look at the person who's not talking to see their reaction as something to consider doing in lots of different contexts on Zoom, whether it's an arbitration or mediation, but the ability to watch people who are not talking can be helpful in a number of different contexts, I've found. One thing to keep in mind is if you're in a mediation, sometimes the mediator will just pop in and you don't expect them. So I've warned the client of that. I asked the client to tell me if they see the mediator and to greet the mediator so that I know if they've popped in. And if I'm doing multiple things at once and don't see them pop in and I'm still talking, somebody tells me the mediator has arrived in the room. One other sort of this is a lot of sort of small technological things, but they can make a difference in any given case, is I always get my client's cell phone number, and you can, at least in a mediation, text with them if they have a question while the mediator is talking to you, or if there's something that you want to be able to discuss even while on with the mediator or otherwise. Sometimes if you want to make sure that you're having a completely private conversation, I will sometimes mute or have the client mute the Zoom and just call them on mute. And that way there's no chance of the mediator popping in by accident and hearing the discussion. You can have a frank conversation without worrying about that. The other thing is just make sure you have the documents in front of your client. It can be even harder to coordinate with them than if you were in person, like trying to find something. And it's just important to figure out every client's different. So you're going to have to find a way to provide the support for your client as an advocate during that mediation in a virtual way. And you're going to have to figure out, is that, having long conversations in between the sessions? Is it just making them feel comfortable with the platform. Everybody's different, but a lot of the success in mediation I found has to do with your relationship with your client. And that relationship and that comfort is really important. So you got to establish
These are
that.
all really important tips. The cell phone tips, so you can have some privacy when you need it. I love that you test the platform because sometimes, your client may intend to be on their cell phone, and if you don't know that, and there may be some difficulties with them participating in the hearing. So you need to, definitely test the platform and ask them to use whatever machine they're going to be using on that day. So really good tips. And I love that you mentioned being competent at reading the room, watching the people who are not talking. And Damali, I know that that you have some additional tips that I wanted you to add about how you prepare.
Certainly. I think I would be remiss if I didn't share some best practices around confidentiality, especially as we continue to operate in a virtual environment. And so usually I do send over some protocols for all the participants in my hearings, whether I'm arbitrating or mediating, so that I can feel comfortable knowing that, for among other things, that no one else is in the room with the person, and if someone comes into the room, that they notify us, which is important because, to piggyback on what Cyrus said, sometimes we're not in the room with them for, long periods of time, and many things can go on during our absence. So we want to make sure that they're still, we're still trying to create a confidential space for the duration of the hearing. And so having them to confirm that they're, in the room and in a private and secured location, making sure that they tell us if they are, if someone else comes to the room. I'd like to have the chat function disabled so that, as they're talking to me or the person is talking to me, that they can't use the chat feature to, talk to people who are also in the room. If they need to talk to their counsel, of course, they should have their counsel's phone number. They can text them or email them, but I don't want to have any potential wires being crossed during my sessions. And so those are some of the protocols that I like to adhere to. And I usually provide this information in advance, so they know in advance what it is that I'm looking for in terms of confidentiality, and in terms of sort of some of the protocols around noise, among other things.
That's great information to share. And Dean and Tamika, I want you to talk a little bit about the new bill that's been signed. I know, Dean, you have some great information on that. President Biden just signed a bill banning mandatory arbitration for sexual harassment claims. Will that change the landscape of cases filed in ADR? And have you seen a decrease in sexual harassment arbitration disputes within your practice?
Good question. First, I would be remiss if, as chair of the NBA ADR section, I did not put in a plug for our panel of arbitrators and mediators. Rebecca's on it. I'm on it. Damali, I don't know if you're on it yet. Even you're on it. So Randa, I would certainly invite you to join the section and to join our panel. In terms of the sexual harassment ban, this actually was passed about a month ago. The House, the Senate, Biden signed it in response to the Me Too movement. And it provides three things that change the landscape of mandatory arbitration, but only with regard to sexual harassment cases. And that is, they will no longer be subject to mandatory arbitration, which means that if you join, say, a major corporation, you sign a mandatory arbitration clause that says that you waive your right to go to court. That will no longer be enforceable for sexual harassment claims. The second thing it does is it allows the court and not the arbitrator to make the decision as to whether the matter is arbitrable or is subject to this ban, which means that there's a case called Harry Schein Harvey Scheinrather in the Supreme Court a couple of years ago that says that it's up to the arbitrator to determine arbitrability, both substantively and procedurally. That has now been changed for sexual harassment claims only, not for FLSA, not for race, not for religion. The third thing it does is there is a case called Epic Systems in the Supreme Court about 3 years ago that started out as an NLRB case that says that class action waivers are enforceable. It bans those for sexual harassment arbitrations. Now, what does this mean pragmatically? First of all, it means that since the primary filers of sexual harassment claims are women not of color, that means that race and religion will now be treated separately. And as a neutral, I take no position as to whether or not this mandatory arbitration ban is good, bad, or otherwise. That's not my place. I just find it curious that Black folks are now going to be treated differently than other folks along with religious claims as opposed to sexual harassment. The second thing is, what will happen where you have a combined race and sex claim? Where will it be heard? And the courts have to answer that question. The next thing it does, and I think I'm being a little selfish here, but with the courts, because of COVID, now totally gummed up. I know in Jersey, we're looking at 3+ years to get to a jury trial. I do a lot of presumptive ADR, a lot of presumptive mediation in New York. You're looking at the same thing. These cases that were going to go to arbitration and now going to go to mediation, or rather to court, they will not be heard. They will help my mediation practice. So anybody here who does employment mediation, I think is going to benefit. I think Tamika and her employer clients, I don't know. Tamika, you tell me, is this good, bad, and is it a fair statute that it applies to non-race claims, to sexual harassment claims?
So first, I was literally on a panel for the NBA like last month, and we were talking about breaking the bias. And I'm just going to speak to that a little bit because like as a Black female, we spoke about and discussed like for sexual harassment cases, you cannot separate race from gender. You cannot do it. So it is a little, as you said, Dean, it is odd that the way the courts, the way the legislature dealt with this. I also, that being said, I think that similar to New York, which is where I practice, they're ultimately going to, and it's just going to be slower, move away from this notion of sexual harassment being or gender being the super protected class. Mm-hmm. That's what I called it before when all of these Me Too statutes came out, and it was like all about sexual harassment and it ignored every other type of harassment and discrimination. And in New York, it took only a year for our legislature to say, no, this is not the super protected class. We're including all protected classes in this statute. So, and
that's what they did in SB 121 in Jersey, which is why this, when you talk to folks, they say, oh, well, the FAIR Act will take care of that. The FAIR Act's been introduced 3 times and it's getting no traction.
Yeah.
I mean, so I will also add before we move on, and I know Dean has to go, that with respect to this, I think it's the statute, the legislation is so new. I know that in New York, even though we had statutes that said like you can't have confidentiality in your settlement agreements, confidentiality is still there. It was as per plaintiff's preference. I would still like to, I'm not sure how this is going to shake out because as Dean said, a lot of these cases are going to move to mediation because the courts are backed up. And when you're in mediation, they're going to have to agree to it's going to become confidential. They're going to move over to probably mediation or arbitration to have these issues resolved quickly. And the employer's not going to do that unless there's an agreement in place. Like the plaintiff is not going to want to wait 3 years to have this issue resolved. So I think it's going to be in arbitration for a while anyway.
Yeah, there are going to be a lot of new realities that arise from this. And right now, because we have to give polls for CE credit, if you would go ahead, Kyle, please, and launch the first poll before we move on to the next topic. Thank you. Okay, so thank you for that. Thank you for that great information, new information. So Judge Trapp, during the pandemic, safety is top of mind, and not only for the employer, but also the employee. So what are some best practices when faced with maybe hazard pay and FMLA or sick leave cases?
Okay, well, I'm going to focus on FMLA, the Family and Medical Leave Act, which prior to COVID, covered employers were obliged to provide employees with job protected, unpaid leave for specified family and medical reasons. And the covered employers were all federal, state, local municipalities, school districts, no matter what size they are. And for private employees or employers, those who employ more than 50 people. And to be an employee, to be eligible to take advantage of the unpaid leave, had to have worked with that employer for at least 12 months, have 1,250 hours of service within that 12-month period. And again, for the private employers with over 50 employees. And with that, the covered conditions were serious health conditions that qualified under FMLA. And those that required an overnight stay in the hospital or other medical facility, the person being incapacitated for more than 3 consecutive days, and including ongoing medical treatment, and that the condition be maybe chronic in nature. And FMLA provided up to 12 weeks of unpaid leave. Well, when COVID hit, it kind of took everybody by surprise, of course, and some changes were instituted. And there was some emergency legislation, the Family First Coronavirus Response Act, which actually obliged those employers to pay eligible employees with paid sick leave. And that was good through from April 20th, and it expired in December 31st, 2020. But the Department of Labor still encourages employers to be flexible with their leave because, as you said, Rebecca, safety is the concern. And that paid leave was only, I believe, for a couple of weeks. So it wasn't a lot, but it was some help and some relief for people that needed it. But where we are now is that some COVID-related health challenges do qualify under FMLA. It's still unpaid, but employers who choose to continue with the paid leave under the Family First Coronavirus Response Act can still get a tax credit. So that is an incentive to employers to continue with it, but they're not required to anymore. But one of the issues that arose is that people, everybody was concerned about coronavirus. People were dying in huge numbers. And so the question became, can I stay home under FMLA if I just don't want to be in contact with other people and expose myself to the potential of getting the virus? And the answer was no. So FMLA only covers if you have a serious medical condition, not something to prevent you from getting a serious medical condition. And so, that kind of flies in the face of, well, we want everybody to be safe. Well, you're safe if you stay home, but if you stay home, you don't qualify for FMLA. Various states have different laws, and I know later on we're going to talk about what California is doing, but that's basically the state of affairs with FMLA.
Thank you for that, and thank you for the clarification around it. Let's continue discussing employee accommodations. Cyrus, how are you dealing with remote work related accommodation disputes in your practice?
So in my advocate cap as a plaintiff's attorney, if someone was asking for advice about they wanted to start a new practice area, I would say you should probably start a practice area of work from home accommodation requests, because there is going to be a wave of these claims coming. And remember the time years ago when working from home seemed like this very, very rare thing? People would say it and they'd be like, my God, how did that ever happen? Well, we all just engaged in this societal experiment about working from home. And for people who have a disability under federal law, or here in New York City under the broader New York City human rights law standard, the usual employer response was, well, that would be an undue hardship if you were working from home on the company for whatever reason they would say. Or they would say, well, your particular job, you would not be able to do the essential functions of the job with that accommodation, if you needed that accommodation. So either with or without the accommodation, you can't do the essential function of the job, and therefore we're not obligated to let you work from home. Well, that argument does not sound very good today, because most people, it turns out, probably can't work from home. And so there's this swath of people who previously wouldn't even try to request to work from home, who in the future, for that employer, and even particularly for their position, if they subsequently request an accommodation of working from home, the employers are going to have a very, very difficult time describing working from home as an undue hardship, or arguing that they can't do the essential function of the job they already did from home, or their predecessor did from home. So this has changed, in my view, this has changed the landscape of work from home accommodations. Some employers are sort of, stopping work from home accommodations for everybody, not accommodations, work from home arrangements for everybody, and saying, okay, everyone's coming back in, we're going back to how it was, sort of just having amnesia of what it used to be like, and implementing the policies they had prior to coronavirus like nothing happened. And that is not a good idea. That is not a good idea because once you deny the person that accommodation, you're potentially on the hook for an ADA or city human rights or state human rights law violation. There are sometimes this sort of just dogmatic stances by employers, because some other employees get mad, or they always did it this way, and so they always had this policy. That is a horrible idea to do that as an employer now. And if you're going to do it, an employer really needs to think through and ask themselves, what is the undue hardship of John working from home? And obviously there'll be people who have disabilities after COVID and can point to the prior accommodation, the prior work from home arrangements of the entire company. But one area in which this is going to happen increasingly is, along with the pandemic of COVID, there is a silent pandemic of mental health,
Yes.
mental health struggles and disabilities. And so
Yes.
there will be a large population of people who do have mental health disabilities that qualify for protection under federal and particularly under city or state law here in New York, who are going to be able to say, I have an anxiety disorder. Getting on the train full of people to work that is anxiety inducing. Going into an office with people, that is anxiety inducing. And there's a stigma about mental health and mental health disabilities in this country still. But those folks are going to be a large population, and it will be very, very difficult to say that, well, you have this mental health disability, but it'd be an undue hardship, even though you worked from home for like 2 years and like did a fantastic job while you're doing it. So that's something that's going to be happening, is already happening. I think will continue to happen. The other part of that not all employers realize is, as people will be more likely to request working from home as a reasonable accommodation of their disability, in many cases, a mental health disability, it is retaliation to penalize somebody for requesting an accommodation. So, what people usually would, 3 or 4 years ago, people would say, oh, John wants to work from home. It's so annoying. Like, he thinks he can just work from home and he's not going to do a good job. And when he works from home, not everything is retaliation, but a lot of things are retaliation if it's connected to the request to work from home. And as that request becomes more commonplace, as people, for the reasons I'm saying, are going to be having valid claims, valid requests to work from home, employers are going to have to really think about, are they doing things sort of in a knee-jerk reaction that is creating liability for them? So the takeaway is, employers need to be incredibly thoughtful for each accommodation request from working from home, and really, really go through the legal analysis and ask themselves, do we really mind if John works from home? Probably it's fine. So if I were advising employers, which I don't do, I advise employees, I would advise employers, unless you have a really good reason for someone not to work from home, you should probably let them work from home if they have a disability under federal or city or state law.
Yes, and thank you for bringing that up, because a little later we'll touch on really something that Oprah Winfrey is looking into. Your zip code makes a difference in these accommodations, and we'll talk about that a little later. But Damali, in your practice as a neutral, what are you seeing with regard to, what are you hearing with regard to accommodation requests and how employers are addressing those?
I was focusing my, I guess my response more on how accommodations are coming up in hearings. So in
Yes.
hearings for mediation, arbitration, more so than how they're coming up with employers. And so
Yes.
for as a neutral, clearly, of course, we have to follow both state and federal guidelines with respect to how the process can be conducted if a person is requesting accommodations. So, of course, the ADA, among other things. And so usually what we're asking for, what I'm asking for, is if any accommodation is needed, that the person put me on notice to give me an opportunity to prepare, to provide the accommodations that they're requesting. So, for example, if there's any, if someone needs help with any verbal or written communication, or if they have to have certain breaks during the mediation related to, disability related fatigue, medical treatment, medication, et cetera, to put me on notice in advance of the hearing so that I can make sure that as I'm conducting the mediation process, that I could be aware of those things. Sometimes the person may need a helper or an assistant to be present. And so again, tying back to what I said before about confidentiality, just putting me on notice so that I can, provide the appropriate statement to inform the parties of what's appropriate to inform them of. And also just kind of being aware of any other shifts in the process that need to occur. So I guess and the main takeaway is to put your neutral on notice in advance of any accommodations that you as counsel need for yourself or for your clients, so that we can make the process as smooth as possible for anyone who needs accommodations.
That's really important. Thank you for that. And Tamika, with long haul COVID-19 related issues arising more frequently, how are employers handling employee accommodations and leave requests? Thanks to that, Damali, I kind of switched my focus on your question, but it's more for Tamika. Thank you.
No problem. So first, let's just take a step back and make sure that we understand this whole term of long COVID or post-COVID or long haul COVID. So the CDC actually coined this term, and it's to describe the various post-COVID condition effects or that an individual will experience after having COVID, whether these are new, returning effects, ongoing health problems that last 4 or more weeks after having COVID. So in this sense, what the CDC said is, listen, when someone has COVID and they're no longer testing positive for COVID, doesn't mean that they don't still have some ongoing health effects from having contracted COVID. And so what the EEOC has said is that the long haul COVID or long-term effects of COVID may be a disability under the ADA. Now, if you look at local law, New York City law, for example, and New York State law to a lesser extent, New York City came out immediately and said, having COVID is a disability. That's it. That's we're gonna call it what it is. It's a disability. And so, but now that we've been in this environment for 2 years, there's a more nuanced response. We're now looking at it and saying, okay, listen, you know, a person who had COVID-19 may actually have a disability if that person's, you know, medical condition or the symptoms from COVID-19 are long lasting and it has a physical or mental impairment that substantially limits a person's major life functions. So I'm just going to give you an example of that. You might have someone who had COVID-19, they were diagnosed with COVID-19, and they have ongoing experiences of headaches, dizziness, brain fog, you know, disability, difficulty remembering things and concentrating, you know, and that person's doctor might say that there are substantial limitations in their neurological and brain functioning.
Well, I've had to learn to walk again. Have you seen, I mean, just, yeah, from the respiratory effects.
Yes,
Yeah.
exactly. So, you know, and then on there's another aspect to it, which is if someone already had a pre-existing condition that COVID exacerbated. So again, you have someone who maybe had a heart condition or a lung condition, and now, like you said, they're learning how to walk again because of what happened to them when they had COVID. It worsened their conditions. And so in this respect, what employers are doing exactly what was previously said, which is that, and I advise my clients, you need to look at these reasonable accommodation requests very carefully. We have now, the world has been shown you can work from home and be productive. So you need to look at it and you need to determine whether or not there is a reasonable accommodation that allows the employee to perform the essential functions of the job, or whether or not that employee could do it with or without a reasonable accommodation. And again, because I'm in New York, you have to look at New York. New York is extremely broad. They'll say a reasonable accommodation is this employee not coming to work for a little bit. Like that can be an accommodation. So employers need to be looking at, and this is what they're doing, they're engaging their counsel and they're looking at the federal laws, the state laws, and the local laws to determine whether or not this person is disabled under those laws. And if so, whether they could do the job with or without a reasonable accommodation, which obviously could now require working remotely, and then whether or not there's an undue hardship in connection with that accommodation. So that's how it's changed it. Nowadays, you're going to sit there and you're going to undertake that individual analysis for each employee. There's no bright line rule that you're going to apply to everyone. You're going to look at that employee as an individual and see what you can do to accommodate that employee. I also want to note that Cyrus mentioned retaliation really quickly, and I call that the gift that continues giving, because he talked about valid claims for a request for accommodation. how about an invalid claim for a request for accommodation? You can ultimately not have a disability under the law. There cannot be, maybe you can't do the job with or without a reasonable accommodation. However, your employer does not get to take adverse employment action against you simply for requesting that accommodation. So you can have the underlying employment claim dismissed, but still have a very valid retaliation claim, which is why we advise our our employers to look at those requests extremely carefully, especially in this day and age.
Well, very, thank you. Really good overview. I appreciate that. We're going to go across the country now from New York to California and ask Judge Trapp about the state of California COVID-19 supplemental paid leave. Can you tell us a little bit, Judge Trapp, about the employer compliance requirements?
Yes, but first let me go back and say under FMLA, at the employer's choice or the employee's choice, instead of using the unpaid leave, an employee can use or could be required to use accrued paid sick leave. So if you have some accrued, the employer can require you to use that first, or the employee can elect to use that. So moving on to California, there's a piece of legislation that was signed on February 9th, 2022, retroactive to January 1st, 2022, which is called the 22 COVID-19 Supplemental Paid Leave Act. And covered employers in the public and private sector, and in the private sector, that's anybody who employs more than 26 employees, are obligated to provide their employees with up to 80 hours of COVID-19 related paid sick leave from January 1 through September 30, 2022. Paid sick leave if you have accrued paid sick leave. So they're not giving you a gift. This is sick leave that you have accrued that you are entitled to use. And it has to be provided to the employee immediately upon oral or written requests. So Ms. Hardy talks about considering those requests for accommodations very carefully. Requesting the paid sick leave in California, you can do it orally. So that'll be a challenge for employers out here to consider very carefully what someone walked into your office or called you up on the phone and said, I'm taking a COVID-19 test and I want to use my 22 COVID-19 supplemental paid sick leave for that. And so it's broken down into two sections. You can get up to 40 hours for the employee and family and other people who qualify, children who, if their school is closed, then it qualifies for you to take care of them. But you can get up to 40 hours for testing, for the COVID shot, for the booster. Every time you get a booster shot, you can get up to 3 days of paid sick leave if you have accrued it under this statute. And then you can get another 40 hours for full-time employees if you actually contract COVID-19 and you have to quarantine and be at home for a certain amount of time. You can get another 40 hours for that. So that is basically California. And now with the different variants, and like Vice President Harris, fully vaccinated, double boosted, and came down with COVID, but she doesn't have any symptoms. But in California, even though she has no symptoms, she could, take her sick leave, her paid sick leave that she has accrued.
Yes, yeah, double boosted. Oh my goodness.
Boosted. So that does raise the question, if certain variants have certain, people react to them differently. So if you're not sick, but you still need to stay home for a certain amount of time. But if you're not sick, are you entitled to take that accrued paid sick leave?
Yeah, the variants are all cousins from the original strain, but there's no telling how different people will react to the different variants. So yes. So on that note, we're going to launch our second poll. Please respond to the poll, and then we will continue with our program. Thank you. So Cyrus, in keeping with the work from home requests and return to office issues, there's an increase of employees we've established who are requesting to work from home. What disputes do you foresee that we are going to be looking at on return to office? Do you think employers will see a rise in accommodation requests? So we've kind of covered that. We've talked about that, and we've also talked about. I just wanted to see if you have any additional thoughts around that topic. But with the accommodation requests and considerations, just was wondering if what you think we will see in variation. And if you don't have anything to add to that, I'm going to ask you and Judge Trapp and Tamika to weigh in on employees working more on virtual platforms and the dress code, any dress code violations. If you've heard about any dress code violations in hearings or from your employers, Tamika, or disputes that you've seen, Cyrus, come up from the employee standpoint.
Well, on the first question, there is a lot of this happening. So people have been working remotely, and then someone says, that's it, everyone's coming in. No one's ever, it's not usually like everyone's like amazing. There's obviously people who, are usually not super thrilled. But for folks who have disabilities, a lot of the time what will happen is, or can happen, is somebody's been working remotely. Maybe they developed a mental health disability while they were sitting alone at home for 2 years. And then they have to confront the prospect of now completely changing around the way they've been working for 2 years, dealing with this mental health disability. As I talked about before, there's going to be a large population of that population that says, hey, I have this disability. I didn't have it before. I have it now. I would like to just continue working from home. And again, as I said before, you got to get someone to give you one really good reason why that person shouldn't continue working from home if you're the person making that decision. Also in New York City, you could be potentially liable for that decision. So individually, so you really want to think very hard. But the other part of that is that some of the folks who are being asked to return but have been struggling with stuff, a disability, mental health disability, or a physical disability that has either was not there before or has been exacerbated in some way, some of those folks are going to want leave. They're going to say, look, I've been working through this. I pushed through this for 2 years. I was, loyal to the company. I got my stuff done. Like, I just need some time off linked to my disability in some way. And it's different in different circuits. There's different levels of acceptance of leave as a reasonable accommodation of a disability. Here in Second Circuit, that is a thing. That is a real thing. And in New York City, it's a big thing. In New York City, employers have to consider indefinite. And this is all unpaid leave. This is unpaid leave. But you have to consider and be able to explain the undue hardship of an indefinite leave. That means a leave where someone doesn't say I'm coming back in a month. That means I need to take leave. I don't know exactly when I'm coming back. That's my request for an accommodation. I have to say, in this realm of accommodations and leave, and about 1/3 of my matters have almost pretty consistently involved this. And I have, maybe with 1 or 2 exceptions in 7 or 8 years, I have yet to encounter an employer who got this entire process 100% right. So there's a lot of opportunities to make a mistake in dealing with it. And it doesn't get the attention it deserves from employers a lot of the time, just regarding training people, making people aware of rights, making people aware of local rights versus ADA rights, which are very different. So a claim that might be, fit comfortably in the New York City human rights law, there's a harder standard under the ADA. But some people who've been trained on the ADA standard are working in New York City, and that's a recipe for disaster, I got to tell you. And the other aspect of this is there will be some situations where these two things happen. Like somebody says, I don't want to go into the office. Now that we're all going in, I have this accommodation I need of leave for a couple of months to deal with a mental or physical disability, or to treat or recuperate from that, the effects of that. And then they come back to the office and they say, hey, I'm back now. And then not all employers understand that there is an obligation. It's different in different circuits that interpret differently, but EEOC guidance makes clear the employer has an obligation if that person's position has not been held open, or if that person for some reason is no longer able to do the essential functions of the job like they used to be able to in that position, there is an obligation to try to reassign them to a new comparable position. The EEOC guidance goes to say that there needs to be affirmative steps. So you can't just say, oh, you're back, that's great. Like, why don't you apply to all these open positions that you can find on your own, and like, we'll consider you. The EEOC guidance does not find that is a sufficient level of effort by the employer. And the same is true for the New York City Commission guidance. So, if you take the trajectory of somebody who's out, who's remote, can't go back into the office for a disability related reason, gets that request, comes back. Even when they come back, there are additional obligations the employer needs to think through regarding an affirmative a potential, depending on what circuit you're in and whether you care about violating EEOC guidance, an affirmative obligation to reassign that person in a non-competitive basis. So that does not mean necessarily, okay, there's a position that's open, you compete with the other person. The guidance says, and there's case law that supports an affirmative obligation to assign them on a non-competitive basis, with some exceptions regarding a seniority-based system of promotion or selection. So you can never stop thinking about this if you're an employer, and almost always somebody drops the ball. Don't be that employer. Try to think through those mistakes before they happen.
I see Tamika ready to jump in.
Honestly, I think that Cyrus did a great job, and I don't want to repeat everything he said. I mean, also what I discussed earlier in connection with long haul COVID. I mean, it is just extremely important for employers to reach out to their attorneys to walk them through the process. Most employers don't know or understand that, especially in New York City, taking time off from your job is a reasonable accommodation. And so he's correct in that a lot of employers don't necessarily get the process completely right, or sometimes drop the ball throughout this conversation with their employee. So yeah, I echo everything he said, and I'm just going to touch upon a little bit regarding the virtual platforms and dress code violations. I haven't really seen that much of the dress code violations. Dress codes have actually relaxed a bit, I think, in the business setting since the pandemic. That said, most employers have a dress code policy in place already. The smart employer will engage their attorney to amend their dress code policy to reflect these Zoom meetings and these virtual calls and things of that nature. But I also think that employees are sophisticated enough to have their Zoom outfits ready. So in the same way that we as attorneys would keep our suit in our office in case we got called
at least from the waist up, right?
Yes, exactly. I mean, I'm dating myself a little bit talking about suits in the office, but we know now you just need to look presentable from the waist upward. So, and I think employees are sophisticated enough to know that.
Well, all great points, and thank you for that input. So the this is all evolving, and what we know is we have been dealing with overlapping pandemics, really, and those are, of course, COVID and food insecurity, job insecurity, education issues with people having to educate their kids at home, the civil unrest, and as Cyrus so eloquently discussed, mental health issues. And so the U.S. Equal Opportunity Employment Commission, or the EEOC, recently released updated guidelines that allow employees to make mandated, to mandate vaccines in the interest of creating a safer work environment, because obviously if people come to work and spread it, then they go into their communities and they spread it. But there are exemptions for employees who have certain religious beliefs or qualifying medical conditions outlined in the ADA Act. The ADA, we've talked about that. The exemptions apply unless granting the exemption would cause undue hardship, which Tamika discussed, on the employer under Title VII of the Civil Rights Act. So the EEOC's guidelines prioritize public safety, we've talked about that, over an individual's choice to be vaccinated. Work environments affect homes, and homes affect communities, and communities affect the world, because people are traveling and moving about. So while the effects of COVID-19, the pandemic, can be seen all over the world, there are disparities in access to resources in healthcare in underserved communities. There are in ADR, alternative dispute resolution, the providers who are providing equal access to justice means. And that's what ADR can be, an access to justice. We know that people in underserved communities don't necessarily trust the justice system. And it also means building resources around our courts and ADR programs to foster an environment of trust, which is much needed. Mediations are being used to pull on the thread to unravel those disparate realities and underlying causes. And many of the recent employment cases involve corporate policies regarding vaccinations. So wanted to talk to you around Damali. I want to bring you in to talk about what you're seeing. We know you do a lot of work in law enforcement with the law enforcement agencies. And what are you seeing around access to healthcare, mental health, the civil disputes that are arising out there? What can you tell us about the increase in discrimination cases? Because one thing affects another. So when people in these communities are having problems with employment and their children and mental health, we're seeing that sometimes people are mentally ill who are being targeted by the police. Can you give us some insights on what you're seeing with regard to discrimination cases?
Certainly. Definitely see a rise in the types of discrimination cases. We've seen more race cases, of course, and given the context of a lot of things that have happened over the last couple of years in the US, but also with respect to people feeling as if they should be in a protected class if they're not in a protected class. I recently had a situation where the time was ticking as to when a particular employee had to have been vaccinated by, or else he was going to be terminated, and sort of trying to figure out what were his options in that scenario. The same thing with respect to people who are being more, I think one way to say it is that there's been more dialogue around mental health needs, more than ever, I would say, which is a great place to be, because now, because the discussions are happening, there's more willingness, I'm learning and seeing, on the sides of employers, also on the sides of management within certain employment structures, to find different ways to be more inclusive in their rules, in their processes, among other things. And so I'm seeing what I like to call kind of a renaissance, if you will, in terms of not just in terms of opportunities in the wake of some of the social justice issues that have occurred, and how we address certain types of discrimination cases. So a little bit more creativity. I mentioned earlier about thinking of ways to be creative when trying to resolve a situation. And so for me, I think that definitely we've seen an increase in discrimination cases, but also an increase in the dialogue around certain types of cases, and also more creativity and creative ways to resolve those issues. I know that's very vague, but these are some topics that I can't dive too deeply into.
Right. Right. Yeah. Yeah. I really appreciate that. And as you mentioned, the discussions are very important, and many things have always existed, but have been brought to light and really became hot topics in 2020. So I'd like to hear a little bit more from you and Judge Trapp about the pandemic and social issues. You've touched on the hot topics and whatever else you can share. Have you seen a rise in the need or request for employment trainings around DE&I and mental health? And Damali, I'll let you just give us the last blurb that you would like to share, and then we'll go to Judge Trapp.
Certainly, absolutely, 100% yes. Prior to COVID starting, I think, we were definitely, when I say we, I was in high demand, having to go out and provide trainings on conflict de-escalation, conflict resolution, the art of negotiation, among other things. Over the past 2 years, the increase in trainings for things that kind of fall under DEI, but also are DEI adjacent. So inclusion, equity, diversity, belonging has been a huge component of what we're being asked to do. And then from that adjacent space, thinking about how to have a difficult conversation, or dealing with difficult personalities, or finding ways to provide a safe space for employees and different, employee resource groups, among other types of affinity groups, to share how they're feeling, and to be able to not just to have the space to psychologically share, but also to kind of emotionally share the impact of social justice issues, COVID, I mean, you name it, just being able to do that and bring bring themselves to work and be more three-dimensional. So it's definitely I've definitely seen an increase in the request for trainings, not just for employees, but for management as well, to be able to be attentive to the needs of their employees.
Yes. Yeah, I've seen that too in my consulting work. DE&I, belonging, because companies, we know that in corporate America there is systemic racism, and it's really baked in. It was intentional, and so we are dealing with the fallout from that, with everything else that is going on. Again, one thing affects another. Judge Trapp, what can you share?
Well, it's just the Amen Corner here. Through JAMS Solution, which is a division of JAMS, we provide training to, among others, institutions of higher education. And there's been, I think, an increase in the demand for conflict resolution training on those campuses. And, it always involves DEI. It's a major component. And I think it's more prevalent. There's a lot of talk about social justice issues and, how they bleed over into our everyday lives, in hiring, promotion, what's taught, all those types of things. And Cyrus and I have done some of that work, and it's very timely, it's very taxing, and it's also very necessary work. In terms of mainline ADR, well, let me back up. Title IX work, we do some of that as well. And most of it is dealing with sexual assault, those types of cases. And I'm seeing DEI components to that, with the interracial dating and the schools wanting to be mindful of that and dealing with these issues. When you have an interracial relationship that ends up in a Title IX action, the schools want to be very, very careful in dealing with those types of issues. And then in terms of mainline ADR, I'm not seeing it so much. I have had mediations where, you know, one of the parties wants to use race as an issue. And then the issue becomes, is it appropriate? Is it going to help us reach a resolution? So in some, I think it, you know, it permeates just about everything we do.
Absolutely it does. And the reason is it's structural.
Yes.
Because it's built in, you know, until we can deconstruct what's been in place for so many years, you know, they will continue to need dispute resolvers, which is a good thing for us. So as we wind down and seek to address any questions that we might have from our audience, let's just real quickly touch virtual ADR one more time. We've discussed the cost benefits, and given that travel is no longer really a factor because we have mediation beyond borders, you can select neutrals from anywhere. How can ADR help increase diverse neutral selection, Judge Trapp and Cyrus and Damali? And if Tamika, you have anything to contribute, that's fine as we wind down.
That's a huge, huge question, because in most cases, the parties have to agree. And some people still struggle with that. They don't think that we can provide the same service as someone else. So I think programs like this, organizations like the National Bar Association, you know, pushing the issue, lawyers who are, you know, paying lip service to the cause need to step up and, you know, be very intentional in selecting diverse neutrals and not be apologetic for it. Because as you said, it's still baked in. So we're not immune to it.
Yeah, it's baked in bias. Yeah, absolutely. Cyrus?
You know, what I think it does that's really interesting is the argument was always there before that you could look at the pool of available mediators and say, well, there aren't that many mediators who aren't older white men or whatever the majority group in that geographic region is, and say, I don't know what to do. There's not, you know, there's only so many people available here. Well, that's not true anymore. If you're really interested and committed to the diversity within the legal profession overall, and in ADR, in the neutrals that you're selecting, you can choose a neutral from anywhere in America right now. And if it's a federal issue, they're gonna know. They're gonna have subject matter expertise in that to the extent that it's required. So for me, there's always talk about diversity in the legal profession and also in ADR. And I just have, you know, what I can say about it is the ability to choose a mediator is limitless right now. So it's not, if people are only choosing mediators of a particular demographic or any particular type, that's a choice. And maybe that's the right choice in that particular situation, but not all the time. So if you find yourself always using a mediator of the same protected classification, everyone should ask themselves, why am I doing that? Is that just chance, or is that habit? And a lot of it is habit, because the diversity in ADR is a newer thing. So I just challenge everybody who says that they, you know, support diversity legal profession to challenge themselves to look at some new neutrals to work with, maybe in a different city.
Yeah, that's right. Allyship is a verb, and allyship doesn't only mean non-Black people. It's a noun in the dictionary, but I've been published to say it's a verb. It's action, and actually not just the acknowledgement of it, you know, of the need for diversity and the value of diversity in these spaces, but also the action to make sure that we get it done. And there's some initiatives out there that we are working on to bring this to light even more. Tamika, do you have any last couple comments?
So I would just say that, you know, as an attorney, it's not always as easy to get to choose who we want, especially if you're working with insurance companies. So I think that you need to focus on those times when you can choose your neutral and you have more say. And then you need to go to, there are lots of different places that you can go to look for diverse neutrals. And those are the times when you should do it. I say that in-house attorneys and general counsel, these are things that, you know, to the extent we have you on this call, on this meeting right now, these are the things that you should be directing your attorneys and your outside counsel to be doing or partnering with them when they attempt to do it. The last thing is, I will say is, when I was president of the Amistad Long Island Black Bar Association last year, one of the things I did in New York is we partnered with the New York DEI Neutral Directory. So it's something that the Eastern District of New York is doing. They're compiling a list of diverse neutrals so that when you have those EDNY cases and we have the mandatory mediation, at least, you know, they're there and you can say, can I have that list of neutral, diverse neutrals? I think I'm not sure that the SDNY has caught up yet to this, but we should, as affiliates of the NBA, be demanding that our federal and state courts do their part, put our neutrals on the list, you know, compile lists, make it easy for someone to get a diverse neutral. So that's all I would add to that.
I appreciate that. And Damali, I'm going to bring you in to share some pearls. But I also want to say that in the chat, I have put the website for the NBA ADR sections. I put the website link in there. Well, not the link, but the URL. You can just grab, maybe if you do hit it, it might be a link. But that's in there because there are neutrals ready to work, NBA neutrals ready to work. And we know that a lot of the, you know, the impediment is legacy relationships. We've mentioned people use who they have always used. And then that ugly word, qualified. Well, why wouldn't we be qualified? Judge Trapp, you touched on that. Damali, what are your thoughts?
What I'll add is that I just put in the chat for anyone who's interested, an article that's on the JAMS website that I wrote about 4 ways to improve your network of diverse neutrals. So I'll just encourage everyone to take a look at that, and I'll turn it back over to you, Rebecca, if there are any questions from the participants.
Awesome, awesome. So I'll also mention that JAMS will provide you with the list of our diverse neutrals. We really appreciate everybody participating today. Joanne, do we have any questions before I close out?
Not seeing any questions in the chat. I did see one that asked a question about the CLE materials. We tried to repost it again. If you're not able to download the link, we will circulate it in a thank you email afterwards so that you can get all the excellent materials that were curated for this program.
Awesome. And I would love to, since we have time, thank you for that, Joanne, and thank you for all you do. I would love to get like one last nugget from each of you about anything associated with our topic today. If there's something that you wanted to share and just didn't get a chance to, we have a few minutes to do that. Judge Trapp, we'll start with you.
Well, again, thank you for including me on this panel today. I think it was very informative, a lot of information shared. The only thing I would add is that mediation works, virtual mediation works, hybrid mediation works, and of course, in-person mediation works. So whatever your fancy, whatever works best for you, we can help you with that. So I would encourage people to utilize mediation and other forms of ADR because, as has been mentioned, even though I think the courts in California are doing a little bit better in terms of getting people to trial and getting back on track, it's still taking a while. And this is we always encourage people to try and resolve their disputes short of going to trial. And we do have a wonderful array of neutrals for any kind of case, not just employment, but any kind of case that that might be out there. And I would encourage people to look into it.
Yeah, we're ready to work across subject matters. Tamika, last words of wisdom. Oh, you're on mute.
I'm sorry, did you say my name? I didn't hear you.
Oh,
cut out.
I did. I was asking if you had any last words of wisdom.
Okay, the only topic that we did not get to touch on really quickly, which I would have touched on, was wage and hour claims regarding remote employees. And so I would just caution again, if there's any general counsel out there or employers out there, that you are making sure that you're communicating your policies to your employees about overtime and or logging in when they're not supposed to be working, because these are the types of things that will lead to wage and hour claims. So you just need to make sure that you are firm and consistent with your employees. Just because you're working remotely doesn't mean, as much as we would like to, especially non-exempt employees, that your workday continues 24 hours a day. So
that's a really great point. Thank you for that. Thank you. Cyrus, last words of wisdom.
I just say if your employee asks has a disability and asks to work from home, no should be an option of last resort, given what we all went through.
You hit that hard. That's great advice. Thank you for that. Damali?
I think just as my parting words, I would just say, just think about different ways to be creative as you're discussing disputes and resolution, because I think the last couple of years have shown all of us is that, you never know what's going to be coming down the road, and having an open mind and embracing innovation can really go a long way to help you in dispute resolution. So definitely pursuing mediation as an option for resolving your dispute, and being open-minded to think about different ways to reach resolution once you're there. And Judge Trapp.
Judge Trapp? Yes. Yes, Judge Trapp. Oh, you were on mute.
I
There
was
you go.
trying to unmute, and I didn't mean to cut you off, but I did want to acknowledge two excellent JAMS neutrals that are on this Zoom today, and that's the Honorable L. Priscilla Hall out of New York, and brand new, the Honorable Denise Langford Morris out of Michigan. So you've got lots of options out there.
Yes, lots of options. And there are, again, initiatives out there created to really promote the selection of diverse neutrals. The affinity bar associations are working together, in case you didn't know that. Also, the Ray Corollary initiative is actively working to ensure that there is an increase in the selection of diverse neutrals, not just the listing, but the selection. And also the Defense Research Institute is doing some work along with insurance company partners who are buying in, and also the affinity bars. And I'm happy, as a former commercial insurance professional, I'm really happy to see it, because I was a selector of neutrals, and I always chose diverse when I could. So in closing, just as the second vice chair of the National Bar Association's Alternative Dispute Resolution section, I would like to thank you for joining us today for this program. And my last words would be, stay safe, but don't stay silent. Thank you for joining us today.